Session. The purpose of this morning's meeting is to meet with the Garda Síochána Ombudsman Commission for a general update on its work in the area of Garda oversight and accountability and its views generally in relation to issues and developments in the area of policing oversight, including, of course, the report and recommendations of the Commission on the future of policing in Ireland. I want to welcome once again before the committee Ms Justice Mary Ellen Ring, Chairperson, Mr Kieran Fitzgerald, Commissioner, Mr Patrick Sullivan, Commissioner. You are all very welcome here this morning. And I will shortly invite you to make your opening statement. But before I do that, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him or it identifiable. Members should be aware that under the salient rulings of the Chair, they should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. So I'd now like to invite Ms Justice Mary Ellen Ring to make her opening statement, please.
Thank you, Mr Chairman. Good morning, Chair and committee members, and thank you again for giving us the opportunity to meet with you today. I'm here today with my fellow commissioners, Mr Kieran Fitzgerald, who's on my left, and Mr Patrick Sullivan. Since we last met with the committee, Mr Sullivan has joined GSOC last July after a public appointment service open competition. The Commission was last before this committee on the 28th of February of 2018. On that date, the Commission updated this committee on the fact that there had been no statutory changes since we had been with the committee in September of 2016, but we were then aware of the work being undertaken by the Commission on the Future of Policing in Ireland, which had been established in the interim period in May of 2017. In February of 2018, we also provided this committee with the business case that we had submitted to the Minister for Justice and Equality, which sought an increase in our staff numbers to assist with the development of our usual caseload and also the provision of a separate protected disclosures unit. As you will have seen from our larger submission that we have included for the committee today, the business case was met in full, and to date we had taken on 21 of the 42 sanctioned staff, with the remaining staff to be with us in the next number of months. For the first time in its history, GSOC has a staffing number in excess of 100. 115 people were working in GSOC as of the 30th of April of this year. The Commission on the Future of Policing in Ireland report was published on the 18th of September of last year, and the recommendations for complaints oversight were in keeping with the submissions made by GSOC to that Commission. GSOC welcomed the proposals, and in particular the recommendation at page 49 of the report that, quote, all complaints about the police should be routed through IOPO, which is the proposed tentative name for a new body, to determine what action needs to be taken, end of quote. At a briefing meeting that morning with Ms Kathleen O'Toole, the Commission Chair, she confirmed that all complaints meant from whatever source and that the Gardaí should not be investigating themselves. It is important to note at this juncture that in our fuller submission, we see the word complaint as being any allegation from whatever source, internal or external to the Gardaí, including from confidential human informants or other police agencies, indicating criminal activity or serious misconduct by a member or members of the Garda Síochána. We have included in our submission the police oversight principles which were adopted in November of 2011 by the European Partners Against Corruption group, and note as key principles of those oversight principles, one, that the police oversight body should be sufficiently separated from the hierarchy of the police that are subject to its remit, and two, the police oversight body should be governed and controlled by persons who are not current serving police officers. And those are fundamental oversight principles adopted in this European organisation. These principles are in keeping with the proposals in the Commission The Future of Policing in Ireland report, which has now been endorsed by the Government. GSOC has also recently made a submission to the review group on anti-fraud and anti-corruption measures, which is chaired by the former Director of Public Prosecution, Mr. James Hamilton, as part of that group's public consultation process. GSOC reiterated the importance of independent oversight where allegations of corruption by Garda members are concerned. We've had one meeting with the Department of Justice about the proposed new legislation and have made further written submissions to that department. However, we have not seen any form of draft in relation to the new complaints oversight body as of yet. GSOC, along with the other oversight bodies, the Garda Inspectorate and the Policing Authority, did raise concerns when we became aware that there was no oversight involvement in the implementation body that had been set up to steer through the various recommendations of the Commission of Future of Policing in Ireland report. Of particular concern to GSOC is the issue of matching a new remit with resources. Under the current legislative provisions, in excess of 500 cases went back to the Gardaí from GSOC for investigation in 2018. There will have to be some increase in resources to deal with this caseload for GSOC into the future. It must also be noted that the Garda superintendents and inspectors who deal with these cases currently are spread throughout the country, and consideration will have to be given to the geographic challenges as well. It must be remembered that there is currently a cost to the state under the current legislation, the Garda Síochána Act of 2005. Gardaí are diverted from their usual policing duties to do these GSOC investigations, and thus this has an effect on their time and the resulting Garda costs. GSOC is conscious that if a new complaints oversight body is to succeed, these are issues that should be dealt with in advance of the new organisation being set up. The concern would be that without proper planning, delay and a resulting erosion in public trust in a new body will set in at an early stage. GSOC is itself preparing a new business plan drawing from our own experience and information to assist in predicting the type of organisation that will be required to meet the demands of a new legislative framework. We hope to have that completed by the middle of this year, particularly having regard to the proposed date of the 1st of January 2021, when a new legislative structure will commence. An area of significance in the work of GSOC and any new body is the issue of access to information. A key principle in the EPAC police oversight principles already mentioned is that, quote, the police oversight body's investigators must be provided with the full range of police powers to enable them to conduct fair, independent and effective investigations, in particular the power to obtain all the information necessary to conduct an effective investigation, End of quote. And as indicated, those principles were delivered in 2011. But you'll see that these principles are in keeping with the recently adopted Venice principles, which are the principles on the protection and promotion of the Ombudsman institution, which were adopted in Strasbourg on the 15th and 16th of March of this year by the Venice Commission. And the Venice Commission is the European Commission for Democracy Through Law, which is the Council of Europe's advisory body on constitutional matters. We have noted in our submission to this committee that under the principles adopted in March of 2019, and in particular paragraph 16 of the principles, that, quote, the Ombudsman shall be entitled to request the cooperation of any individuals or organisations who may be able to assist in his or her investigations. The Ombudsman shall have a legally enforceable right in unrestricted access to all relevant documents, databases and materials, including those which might otherwise be legally privileged or confidential. End of quote. These are principles we have submitted to the Department of Justice and Equality that new legislation should have regard to in dealing with the necessary powers required for fair and proportionate independent investigations into the future. The issue of access to information in the Gardaí is a matter which we raised on our first meeting with this committee in September of 2016, and where we highlighted the provisions of Section 66 of the Police Northern Ireland Act of 2000, which includes a statutory requirement on the Police Constable of the Police Service of Northern Ireland and the Policing Board in the North to provide documentation and information to the Police Ombudsman of Northern Ireland. GSOC has noted in its submission to this committee that we have become aware, along with the public, of allegations of Garda wrongdoing through the media. We are aware that the Gardaí continue to conduct criminal investigations of its own members without the knowledge or participation of GSOC, and we find that troubling. This practice runs the risk of allegations of cover-up or bias or corruption when it becomes known that such investigations have been carried out internally. It runs the risk that fair and independent investigations are not seen as such by the public because they were not notified outside the organisation. Most importantly, they run the risk of undermining public trust significantly if such internal investigations go wrong. This practice also flies in the face of the Commission on the Future of Policing in Ireland recommendation that all such matters should be routed through GSOC or the new oversight organisation. In our submission in 2016 to this committee, we also highlighted as a priority the need to establish more efficient processes to deal with service issues. We have included in our submission today the work that commenced in February of 2018 between GSOC and the Gardaí on the Local Intervention Initiative. You will see the spread now of the initiative throughout the country with certain exceptions. GSOC has also paid tribute to the work done by our former staff member, Ms. Pam Howard, and Inspector Greg McAterian of Pearse Street Garda Station in Dublin in promoting and developing the pilot scheme. This is an example where the two organisations can cooperatively and collaboratively use our joint experiences to provide the public a better police service. GSOC and the Gardaí see this as an important process into the future, and to that end we will continue to review numbers and the satisfaction levels in this area. This meets the needs of the people concerned, both Gardaí and public, to sort out issues without resorting to formal discipline investigations. Finally, an area of great concern to all has been the issue over the last number of years in relation to the handling of protected disclosures within the Garda organisation. GSOC sought and obtained an increase in our numbers for these very important investigations. We have set up a separate unit with separate facilities, and the last of the sanctioned investigators joined the unit in the past week. As we have reported, GSOC received 24 new protected disclosures from Gardaí in 2018, and they have continued into 2019. GSOC would be of the view that the continued growth in protected disclosures made to GSOC indicates one of two things: a growing confidence in GSOC to treat these disclosures respectfully, or a lack of confidence in the Garda Síochána to investigate such disclosures. We have noted in our submission the contrast as far back as 2017 in the numbers officially reported by the Gardaí for that year as being 11 protected disclosures made to the Gardaí internally, while the number of protected disclosures made to GSOC in 2017 were 22, double the Garda numbers. It would seem that as new legislation for both organisations is being planned, the issue of how protected disclosures are dealt with over the two organisations could be usefully reviewed to ultimately provide to Garda staff the best and most efficient way of dealing with the issues that have arisen through the disclosures made over the years. And finally, I provided belatedly this morning a diagram workflow. I'm not going to go through it, but it gives a representation of how the current legislation directs us to deal with complaints. And it's a maze, as you can see, in terms of what's required. We hope for a better diagram by the next time we appear before this committee. So thank you
very much, Judge Ring, for your opening statement and for the circulation of this rather difficult to follow diagram, may I add. I thought it might come with a dice and little markers because it did remind me of a snakes and ladders game, but however, that's another day's work. Members, now in terms of your respective contributions, I have indications from Deputies Clare Daly and Jim O'Callaghan in that order. Please.
Thanks, Chair, and thanks very much for coming in. And I mean, in some ways, I suppose it's great that we're talking about this again, but in some ways it's a kind of a deja vu, like that we've had the situation where these issues are being talked about more since your last visit in here, but in the practicality of actually structural changes, particularly legislatively, being put in place, we're no further along the road, really. Well, that's my view anyway. And just maybe a couple of things on the overlap with the Commission on Future Policing and the work of yourselves as the first batch of questions, I suppose. I mean, when the report was published, your press statement correctly at the time, as far as I'm concerned, pinpointed that a lot of what they said echoed what you'd said already. There was absolutely nothing new in it, really. And this could have been legislatively provided for before now, and I have to say I'm incredibly frustrated about that. So a couple of questions flow from that. I mean, when do you think you'll get some sort of a statutory right to information in particular? Because as you've highlighted, this is an area that's been long lobbied for. I think, and it was in actually this committee's report as well in 2016. So have you any idea as to when we might be nearer to getting that statutory right to information? I was very concerned in your submission where you talked about that you found out about the implementation group and that the others as well, the Garda Inspectorate and the Policing Authority, have also been excluded in essence from the implementation group around the Commission on Future Policing, and that was certainly news to me, and I don't like the sound of it at all. I note that you say that after you wrote to the department they said that they'd consult with you Personally, I don't think it's adequate, but I'm looking to, could you explore that a bit more as to whether you still believe that you should have a seat at the table, because I do, and I think anything we can do to assist that would be a help. And just, I suppose, linked to that is, I know you've said you're hoping to have your business plan kind of by the middle of the year. Can you give us a broad brush stroke on what that might mean, and also the points about extra resources? Is it too early to say? And I suppose it's a bit unfair to ask you to comment on the overlap with the Commission on Future Policing, but an interpretation of it could be that we could have had a lot of this in place and been well down the road already if we hadn't had the Commission on Future Policing, because there's no real reason why a lot of this is being delayed for that. So I'll maybe leave that as the first batch, and I've another little batch after that. Yeah.
Okay, Deputy Daly.
Statutory right. The statutory right to info.
Yeah, well, with regard to the statutory right to information, as at present advised, we're aware that the Department of Justice are preparing draft heads of bill for the new legislation. That's what we're advised at the moment, and we have had some preliminary discussions with the Department towards that. But we haven't actually seen any paperwork at this stage. So whether that will be in that head of bill or not, Deputy, we just cannot say at this time. Obviously, it's something, as you said yourself, we've been seeking for a very long time, and we have put various mechanisms in place with the Garda Síochána to try to expedite and facilitate the exchange of information, but limited success, perhaps, would be the best way to describe that. So, as at present advised, we do not know whether it will be a clear statement of access, such as has been outlined in the EPAC principles and the Northern Irish legislation, or whether it will be there at all, or whether some other version of it will be there. We just cannot say with any certainty at this time.
In relation to the implementation group membership, you may be familiar with the publication that has been put out with regard to the timetable entitled A Policing Service for the Future, published by the government. And it's clear, as one looks at the membership, there's significant membership from Secretaries General throughout the public service, similarly Deputy or Assistant Secretary Generals, and so there are a significant number of cross-departmental representatives. There's also, not surprisingly, the Garda Commissioner. But as the legislation is also going to deal with new structures in terms of oversight, I can't help you as to why it wasn't thought that there should be some representation from the current oversight bodies. We have had one meeting with the implementation personnel, but they continue their work at their rate. And beyond that, I'm afraid I'll have to direct questions to them. They have a very ambitious timetable under the supervision of the Department of Taoiseach, and it would appear they are anxious to meet a start date for change of the 1st of the 1st 21. And I wish them best in that regard. We would be anxious for that too.
I mean, it's incredibly illuminating, and I mean, I don't want to put you in a difficult position of having to comment on what the department is doing, but for us, this is a forum to put on the public record some of the issues or tease out what's going on behind the scenes. And I have to say, hand on heart, on the basis of what you've said and the information that you've provided, I am very worried about where this is going, because it's long been my opinion that the Commission on Future Policing in relation to this area, when ye were before us now 3 years ago, where you'd actually drafted legislation. Mick Wallace had previously drafted legislation that would have given us what all of us say we needed, which could have been in place now, and now we have a situation where ye haven't seen any paperwork at all. about the draft heads of bills on this. You've no idea what aspects are included in it, and you can put on the public record that the body that's looking at the implementation is heavy on civil service, heavy on Gardaí, and zero involvement in the oversight bodies, and that is actually scary and unhelpful from the department's point of view. But that's not really a question, but it's to say that, to me, you've provided that information, and it's an appalling spectre, really, but not surprising. I wanted to ask maybe as well about the scenario at the moment in terms of the handling of protected disclosures, which is clearly a growing area that you've been involved in. I suppose, what's the average sort of timescale you're looking at for GSOC to assess and come to a conclusion in relation to protected disclosure? Now, I know they can be broad-ranging, but roughly, like, you know. And what kind of cooperation are you getting with An Garda Síochána? Has it improved in the last year or two? Has there been any noticeable differences in that regard as well? And then maybe sort of linked to that is the area of, you know, what you mentioned in your statements, how you've opened up investigations despite Gardaí not informing you about incidents, that you happen to hear about them in the media or whatever. Like including issues like the temporary loss of a firearm and ammunition and so on. You know, like, did you, like, I'm trying to get my head around how that would happen. Like, I assume you asked An Garda Síochána after that, why weren't you directly involved or informed about these beforehand? And assuming that you did, like, can you tell us what answer they gave, or is there anything you can do to sanction that? I mean, it just shows up a gap in accountability. That's just absolutely ridiculous, really, you know. But if there was any more information on that, I think it would be helpful, you know.
Would you like to come back on that, Judge Ring?
Perhaps just on the protected disclosures, which is slightly separate. We have now got a full complement of investigators, which has clearly assisted in dealing with matters that have been pending and new matters. The rate at which we have been contacted by Gardaí is increasing, and that obviously puts demands, and they are from all around the country. So that puts demands on personnel just visiting with people. We have a process in place which is an initial process of assessing the information given to us. What may be to the person making the disclosure a protected disclosure, first we have to establish what is their basis for saying that, and then we have to look at it from a legal point of view. And we have found for many people it's a very distressing experience. They have had significant long-term experiences where, for instance, something like bullying has affected their work life, their personal life. So in fact, the taking of a statement has had to be done over the course of days, as opposed to in one-hour session, for instance. So they are, even from an early stage, quite complex, and they can be very difficult for the people making the disclosures. We have levels of communication having regard to the protections under the Act with An Garda Síochána, and those are working well enough. Our difficulty in any case, whether it's protected disclosure or not, is knowing whether we have got all of the relevant information. We may ask for A, B and C, and we get A, B and C, and we get A, B and C in a reasonable period. But it's only when examining A, B and C we discover D, E and F are relevant, and we have to go back and make application for those pieces of information. So we can get what we ask for, but we don't always get what is relevant. And at the end of the day, we have to accept that we've gotten everything, but I think I set out in my submission an example of a historical matter going back to the early 80s, where on initial application we were told, perhaps not surprisingly, that they couldn't find documentation. We went to the office of the DPP, and perhaps not surprisingly, they could find the documentation. And then at a late stage was told by the person involved that they had in recent times made an application under data access and got documentation, and we discovered that indeed in the data access office was information where the official request came back with the answer that there was no documentation. I'm not suggesting malfeasance on anyone's part, but it was clear that a line of inquiry was followed. It revealed nothing, so the answer back to us was there's no documentation. And yet, sitting in An Garda Síochána were indeed documents. So we don't know sometimes when we're told we have everything or there's nothing more, whether in fact we have everything or there is nothing more. And there is no sanction in that regard. So it's an ongoing issue, and it may be that something like this will always exist, short of going in ourselves and going through every press and every file. We may not get everything. One would hope that as better file keeping and computerization and better protection of documentation occurs within An Garda Síochána, that we will then get everything. In terms of contact with the Gardaí in relation to investigations, as I say, we have picked up the newspaper or heard on Morning Ireland of a matter which we were, like members of the public, unaware of.
And did you ask the guards, like, why weren't we told, or did they give you an answer? Or?
Well, we have been in contact with them in that regard, and I don't think they see that there was a need to tell us, that they were confident that they were properly investigating it, and that there didn't occur to them that there was a need.
Yeah, and I mean, presumably that's linked to the lack of a sanction, and I think it's linked to your statement as well, where you said it was troubling that they continue to conduct criminal investigations into their members without the knowledge or involvement of yourselves. Now, either they don't know that they're supposed to be doing that, or it's something more sinister. And I suppose, I know you referred to it's very troubling, and the new draft protocol or whatever, I know you say that you hadn't got a response back from the Commissioner about this protocol yet. I'd like to know, how long have you been waiting for the answer from the Commissioner on that? You know, has there been any steps taken to put that protocol in place? You know,
we have an existing protocol that goes back to 2013, and there was one prior to that, which was the establishment of GSOC. And in fact, we had raised the issue of reviewing the 2013 protocol, and then we added a new proposed protocol to the mix. The Garda Commissioner has acknowledged receipt of it and has indicated the matter is receiving attention, and I would...
Is that months or weeks ago, or just roughly, like, or years? Or
March, that
right.
There was an acknowledgement.
Okay.
And I've no reason to believe that they aren't considering it. Yeah. It's just where in the list of priorities that are on the Commissioner's desk do we come.
I know. It's just, it's all piecing together to a very troubling picture. and even more troubling given that we were here 3 years ago discussing the same stuff, where we were maybe even a bit more upbeat that she'd gone to the trouble of detailing the legislative provision that would have sorted this, and now we have not just the lack of change there, but in your day-to-day work. I mean, I'm guessing from, like, you've put on the record that in the protected disclosures incidents, we're dealing with some people who've been incredibly damaged by what has happened to them or what they've perceived to have happened to them without adequate investigation, going on for days like an investigation. Then at the same time, you've said ye continue to have an enormous difficulty in getting documentation. I'm guessing that the adding of the two of those together means that the process for carrying out the investigations into the protected disclosures is generally very long. And would I be right, or would you know, like, that most of the people in that situation, they presumably wouldn't be in work? And what's the level of crossover? Like, for example, I know there was one protected disclosure that she had finished your report into, very serious case of alleged Garda involvement in the drugs trade, and that in tandem with your investigation, there had been an internal Garda investigation. But because the internal Garda investigation wasn't finished, even though it went on for about 4 years, ye couldn't print your conclusion of your report until that one is finished. I mean, is that not just the biggest flaw ever? Like, does it not make the job of GSOC completely stunted in being able to do anything? Because presumably then an obstreperous Garda management, and I'm not saying that that's what that is in this case, but if somebody wanted to use that to delay it, they could. We're still internally investigating. And like that level of, do you have much interaction in a human resources point of view with An Garda Síochána in terms of the actual Gardaí who are in the middle of what for them is a nightmare quite often, in terms of their working environment while their complaint is going in tandem, and how it's kicked between the two organisations?
Well, I finished by saying it seems, if we're looking at new legislation, for the two bodies, a good time to perhaps look at the whole process of protected disclosures, because technically under the law we can't discuss if it means identity is in some way disclosed, and so we may in fact be investigating a complaint that the Gardaí are investigating, but we may not know that until very late in the day. They may be very far advanced because they're closer to the information, which then causes problems for our investigation. And it seems to me that if we're going to have a structure which allows for two organisations to take protected disclosures from staff, then there should be some effort made to allow for better management of the protected disclosures. And it is something we raised in the general sense, where submissions were sought by deeper in relation to the 2014 Act, the Protected Disclosures Act of 2014. We made a submission to them about the fact that we can't talk to Justice, who may have had a letter or some submission. We can't talk to the policing authority, who may have also got a letter or some submission, and the Gardaí, and 4 bodies may have information about the same complaint, but there's no mechanism to allow us to disclose information except in a formal investigative way with An Garda Síochána. And we raised that with the Department of Public Expenditure, who are the lead agency on the Protected Disclosures Act, and they decided not to deal with that issue in that review, which was taking place, I think, in 2017, of the Protected Disclosures Act. So there are many issues also in terms of welfare arising, as far as we're concerned, and we make it very clear to a discloser, welfare is a matter for An Garda Síochána. We're not a welfare agency. Many of the people that come to us are out sick or have been out Some are working. Some allegations include lack of advancement because of, and these are issues that we have no control over. We can only investigate the allegation. The Gardaí are still responsible for their staff, their members, and they need to deal with the employment issues, the health issues, the welfare issues. And we've made that very clear as well.
You paint an incredibly depressing picture. For all, I'm not blaming you for that. I mean, it's disgraceful as far as I'm concerned now, the situation we're in. Years on, where a lot of these issues are being flagged, and in fairness, you haven't been shy about spelling out the damage that's been done to some members of An Garda Síochána who are making these disclosures, but also members of the public who aren't getting answers because your hands are tied. And I mean, the fact that the Department of Public Expenditure didn't take on board the information of your lived experience of the shortcomings. You're not being consulted in a real sense about the changes that are due. Really sums up the Department of Justice as far as I'm concerned, but that's a comment that I appreciate you probably can't say. But look, thanks very much for coming in. It has been useful, albeit scary as well. And I'm sorry, Chair, I have to go, and it's not. I will follow up on it later. It's just have to be somewhere else as well.
Daly, thank you for your contribution. Deputy Jim O'Callaghan.
Thanks, Chairman. Thanks very much for coming in, everyone. The Commission on the Future of Policing recommends that all complaints should go to IOPO, and my understanding of all complaints would be that it includes minor complaints. Do you agree with that?
I think you can do that.
Yeah, it would include minor complaints, and at the moment a lot of minor complaints do come to us. If I understand your question, I suppose the best way is to define how we break up complaints, Deputy, and that would be in the minor complaints area. There are even categories within that. Some we categorise as service level complaints, where perhaps a level of public service in terms of perhaps just common politeness is not observed and not delivered by the Garda Síochána, allegedly, by a complainant. That was the local intervention scheme that the judge was referring to in our opening statement. We've tried to establish local intervention, and in fairness to the Garda Síochána, especially at the pilot stage, they engaged very positively with it, and it is showing green shoots. And the Garda Síochána have looked to roll it out, not fully nationwide, but significantly widespread throughout the country. That would deal with the very, very minor complaints. For example, non-return of a phone call, simple politenesses or discourtesies. But there's another level of complaint that would still perhaps be a less serious complaint, depends on your perspective, obviously, but where there would even be discourtesies that are not suitable for that, that are still somebody feels they need the vindication of bringing it to an oversight body. So they do come to us, and they would come to us into the future, according to the Commission of the Future of Policing. We, at the moment, under the current legislation, can send many of those back to the Garda Síochána. Into the future, that wouldn't be the case. We would deal with them ourselves, which is why, for example, the judge again was referring to the issue of resourcing for those, because they obviously occupy a fair bit of Garda resources at the present time, and they would in ours into the future. So we've no difficulty with that. We think it's right that they would come to us. Where appropriate, the local intervention is a very worthwhile initiative and something we will try to reinforce and work very positively and closely with the Garda Síochána to implement it. A lot of those things, as I say, basic public service, should not be the subject of complicated investigative mechanisms that are resource-heavy and very adversarial and confrontational. The whole process at present is structured around finding a Garda, if you like, guilty of misconduct or guilty of a crime. What we really try to focus on in the new legislation is resolving the problem. And at the minor level, resolving the problem is much more significant than when you get into the more serious complaints, where perhaps there is serious misconduct alleged or a crime alleged, where obviously
Yeah.
other sanctions are more appropriate.
Like, obviously, I recognise and I agree with you that you think that a complaint should be a complaint related to serious misconduct, or I think you mentioned it, or indicating criminal activity. But are you aware from, I suppose, discussions with the department or from your reading of the Commission on the Future of the Policing report, like, is it intended that you will have to deal with minor issues and that you'll have no option about referring them back to the police if the legislation is drafted in accordance with what appear to be the recommendations of the Commission? Was that a concern? Or?
It's not particularly a concern of ours. We have said that all complaints should come to us. The Commission says all complaints should come to us. We'll devise mechanisms to deal with them. It will be a big workload.
Yeah.
There's no question, and we're nervous about that in terms of resourcing.
Like previously, I thought you had wanted, maybe I'm wrong about this, that you'd wanted to try to get rid of the minor level complaints about rudeness and guards not giving sufficient attention to members of the public.
Sure,
but you can
and
understand
as I say,
as more of a
sure, as I say, that's why we instituted with the Garda Síochána the local intervention scheme to try to actually not have those turn into complaints.
And that was a good idea. Yeah. Can you, like, in terms of the IOPO, like, how does the remit of that, do you think, how is it going to be different from the remit you have at present? And I know that's a difficult question because you're not drafting it, but based on your reading of the Commission's report.
Just before my colleagues kick in, and it's tied to your earlier question in terms of all complaints coming to us, there's never been a definition of a complaint in the 2005 Act or any of the amendments thereafter to it. It would be something very useful. We've said in the submission very clearly, and the Commission on the Future of Policing have said, all complaints. Now the question is, what is a complaint? So, for example, as the judge outlined in our submission, we see that, and internationally it would be seen as all complaints of wrongdoing or all information that would... So at the moment I think we assume that a member of the public has to walk into our office or get online or walk into a Garda station and say, I want to make a complaint about Garda conduct. That does not necessarily include information that comes to the attention of, for example, the Garda Síochána, of criminal activity on the part of a guard or misconduct. Say somebody's in custody and he or she says, well, I know of Garda X who has done something egregious. Well, as we say, that may never come to us, but it is in fact, or can be interpreted as a complaint about Garda conduct. So we need to be very clear into the future as to what we deem to be a complaint.
Okay. Well, I suppose that's a responsibility for the legislature as well. We need to define it precisely, don't we?
It shouldn't be left
vague
to interpretation on the ground.
But do you think, looking at the Commission on the Future of Policing's report, is there a new remit that is going to be given to the Ombudsman when the new one is enacted, or what do you think? Judge, you're smiling there.
Well, we're in the dark. Let's be frank on it. Kathleen O'Toole laid it out very succinctly.
Okay.
She used the phrase all complaints. But on a question from my colleague, Patrick O'Sullivan, when we met her about what she meant by complaints, she confirmed that she meant all allegations of misconduct, criminal activity. How that translates then into legislation is first for the drafters, and then it's for you and your colleagues in terms of the passing of the legislation. We're highlighting concerns. We're saying that if it's a narrow definition put in an act, then we will have a narrow remit. If more clarity is given in terms of what a complaint is, etc., then we can work in a broader way. And so ultimately, it's first for the department and the parliamentary draftspeople, but then it's for yourself and your colleagues.
Okay. And obviously, I know the Oireachtas would appreciate your involvement because you've had the experience of dealing with these issues for a long number of years now, you know. Can I ask you as well about the Venice principles? And principle number 16, which you say you believe should be incorporated, and I think you refer to it, Judge, on the third page of your opening remarks, and it's highlighted. and you believe the Ombudsman shall have a legally enforceable right to unrestricted access to all relevant documents, databases and materials, including those which might otherwise be legally privileged or confidential. Now, that's quite a broad, very large power for a statutory investigative body to have. Like, what type of legally privileged documents would you be seeking access to?
Well, in terms, I didn't write these principles,
okay, I know, but
and they came about.
Yeah.
I can only suspect, after a lot of contributions,
Yeah.
discussion, and insofar as it would have a practical application in this jurisdiction, it is unlikely to get to that extent.
Yeah, I would have thought so.
However, having said that, if documents rested that were relevant to our investigation, rested in the legal section, for instance, of an Garda Síochána,
Yeah.
they might be pivotable in terms of what people were advised to do, and that may answer very serious questions we have as to what we see people did.
Okay, and are you frequently refused, or have you previously been refused access to documentation by the Gardaí because it's, according to them, legally privileged?
Yes, and I mean that's not unexpected.
Yeah, of course. Yeah.
And we perhaps might say the same thing, though we have waived legal privilege in instances where we have felt they would be helpful to other parties.
Yeah. And do you think that needs statutory underpinning, or is that something that can just be achieved where things are at present, the current legislative mechanism, and obviously there'll be a row in the same way as there can be a row about legal privilege? So it doesn't need new legislation for that to be implemented, is it?
I think it should be clear that this is the extent, whether in every case it is appropriate, proportionate, relevant, will be something that on a case-by-case basis can be relied upon. So if we say we want to look at your legal advice, we would have to explain why we feel it's relevant and what, on a proportionate level, is our argument. But the danger is that if you don't want to give documentation, you deposit it with the legal section and claim privilege, legal privilege, and we may be able to litigate it through the courts and have a judge, for instance, independently look at it and decide that it is important to an investigation. But that's at a cost and a delay. And I'm not saying that if it's included in legislation, it would be able to be used in every instance, but it does mean that it avoids the, as I say, resting of documentation that could be relevant in a legal section.
But say you were investigating a guard, do you think that legal advice he personally had received would be accessible by you?
Not necessarily.
Yeah.
I'm not saying, as I say, that in every case
of course,
we would resort to it, or that people wouldn't still have the opportunity to rely on legal privilege.
Okay.
But if we are told in the course of an investigation, particularly a serious investigation, that they were advised by the Gardaí, the Garda Legal Services, that they were to do X, Y and Z, well, unless we had sight of that, how do we measure whether they're telling us truthfully something?
Okay. Just another point that was raised by Clare with you, if I could just ask another question on it. This is about Gardaí continuing to conduct criminal investigations of its own members, and you've no knowledge about this. And like, you become aware that, say, you hear something on the radio or you read something in a newspaper. Do you take steps after that, or is there anything you can do to try to stick your noses into it, as probably you should be involved in it, of course?
We can always open a public interest investigation under the current legislation, but as I say, sometimes that's well after the horse is bolted. For instance, I read about a case where the guard had been returned for trial in the circuit court.
Yeah.
So it was a case where the DPP had already directed a prosecution. there'd be no point at that stage in us opening a public interest investigation because the matter was before
Why
the
hadn't
courts.
a case like that come to GSOC? Was it because the Gardaí hadn't referred it on, or they were just operating a separate criminal investigation?
There's no statutory obligation on them to do so.
Okay.
So they're not under any legal obligation or any pressure to refer those to us. The worrying factor is there is the case, for example, where you read in the paper that perhaps a Garda has been returned for trial. What you don't know is how many investigations occurred which we've never heard of.
Okay. So there clearly needs to be...
And they're the ones that you'd probably be more troubled by. I mean, if a Garda is coming to court at foot of another Garda investigation, it looks like it's been pretty efficiently done. But we don't know about the ones that go nowhere.
So you think there needs to be a statutory provision in place that requires the Gardaí to inform you, and obviously you can still cooperate with each other in terms of an investigation,
Yes.
but that there should be a statutory provision in place that you're automatically
Yes, because
informed.
they fall under what we're talking about, the definition of an allegation of some wrongdoing on the part of a Garda should be notified to the Ombudsman, yes.
Okay, and just finally, you've had the, first of all, I want to commend the fact that the previous time you were here, there was an issue about your business plan not being implemented, you hadn't been given the resources, and in fairness to the Minister, he stood up to the plate and he delivered that. How many now work within the Protected Disclosure Unit?
We have 8 investigators.
Yeah.
We have an executive officer in the civil service rank who acts as an administrator, and we have sought the services of an analyst.
Yeah.
There isn't a panel available within the civil service, and they're going to get a panel available, and so hopefully by the end of the year we'll have an analyst and we have a senior investigating officer in charge.
Okay, thanks very much, Irvin.
Deputy, if I
Sorry,
may
Ken.
just to come back to one of your earlier questions, something I neglected to mention. You asked about the remit. Will the new body have a completely different remit? Well, it won't have a substantially different remit, but one important line in the Commission of the Future of Policing is where they recommended that we, or the new body, focus on investigating incidents, not individuals.
Okay.
And I think that will be a significant change and allow us to look at an event and what it's about, rather than this sole narrow focus, very restrictive focus on whether a particular Garda has erred in their conduct or not.
Yeah, I think that's a good idea.
And I think that will be a significant change to the way we'll be able to do business.
Yeah, thank you all very much.
Thank you. Thank you, Deputy O'Callaghan. Deputy Jack Chambers, please.
Thanks, Chair, and I thank all of you for attending and your comprehensive submission as well. Just on the point of, obviously, when you've been here previously, there's been an issue detailed around cooperation and the deficit that can occur there, and the fact that you've spoken in your statement and in your submission about the need for legally enforceable access and unmitigated access to various information and evidence. Has cooperation improved in recent times, and just around the channel of that, like, you know, where is there particular areas where there's pushback? Have you noticed, like you mentioned, trends emerging in particular areas, which I'm going to go into, but say, is there been can you just outline, say, the trend around cooperation in your engagement with in various investigations, and just maybe provide some more information on that?
We have seen better cooperation, and I think that's because both organisations are recognising the work that we each do. I'm going to take the opportunity to compliment the work of Chief Superintendent Margaret Nugent, who is in Internal Affairs, who is our conduit for requests for information and general contact in terms of our investigations, both from the protected disclosure and the ordinary way. And she and her colleague, Superintendent Helen Daly, have been excellent to work with. And they are supported clearly by, for instance, Assistant Commissioner Dave Sheehan and ultimately the Garda Commissioner. So yes, there are people at high rank who are clearly supportive of the work GSOC does and anxious that we get cooperation. We don't just deal with chief superintendents, assistant commissioners, and it's at those levels that we can run into difficulties. So, for instance, we have this process called the Garán process to look for information, and again, the personnel there we have great contact with. They deal with us effectively and efficiently, but they make the request to their colleagues in particular stations, in particular areas around the country. And that can be where it gets spotty. And the personnel in the Garán process, no more than ourselves, takes on good faith what they get supplied to them and they supply to us. The question is, have they got everything? Have we got everything? And so I think there is sign of change, and obviously that has to come from the top, but it needs to be recognised throughout the organisation. And people tasked with the job, for instance, of making documentation available must understand the importance of making it available on the first asking and not deciding that they will give certain documentation or certain information and not others, unless specifically asked. So yes, and we recognise these individuals as playing an important role, but we would like to see greater cooperation throughout. And the local intervention initiative will hopefully foster within local areas, within local Garda stations, a more cooperative approach about dealing with the public, which will then feed back also to dealing with ourselves. So time will tell.
And have you seen any geographical trend around resistance? Or is it varied?
It's varied. I mean, in our annual report, and I indicated it would be laid before the Houses of the Oireachtas today. I understand it gone back for a week. But you should be seeing our annual report for 2018 soon. But we set out, for instance, where complaints come from in terms of the country, and in some instances, chief superintendents have come to us to look for further information, to dig down in their local area, and we've given them that information, and we have seen a reduction, say, in the following years. So again, I'll name check. Chief Superintendent Dominic Hayes in the Kilkenny area came to us, I think 2 years ago now, and noted that certain figures relating to his district were set out, and he wanted further information, and we saw a resulting reduction in the following year. So again, it can get down to people being curious, looking for information, and acting on foot of the information.
Regarding the 500 complaints that were reverted back, and I know when we've had discussions with you before, as my colleague Jim mentioned, obviously what's happened with the Future Policing Commission report is a whole different arena than where you're at present. But what's your kind of follow-through or audit of the cases that are handed back, and do you seek an update on the conclusion of all of them, or are they just handed back? Or can you just provide the governance mechanism for that?
The complaint comes to us, we send it out for investigation. The results of the investigation come back to us. So we do know what the outcomes are. We have no involvement, unless we're supervising it, in the actual investigation. And again, in fairness, superintendents have sanctioned, in terms of outcomes, their own colleagues. So it isn't that they find no misconduct. In fact, they can find significant misconduct and be quite proactive in dealing with their colleagues, but they go out, and we've indicated in our statistics, because as superintendents and inspectors, they have a lot of things on their plate, and some come back to us fairly quickly and others take longer.
So just regarding the various trends you've mentioned in the conclusion of your submission, obviously we've a historic issue around supervision, and they're trying to improve that with various promotions, but is that, that's obviously having a significant impact on the quality of follow-through, and you've also mentioned around communication. That's something I can see, when stations have still hemorrhaged significant staff, the follow-through, which breaks down confidence in some levels of policing where they haven't got the communication, whether it's a positive or a negative result. I suppose, you've obviously engagement with An Garda Síochána. How do you, kind of, for general dissatisfaction that I suppose you've highlighted in that kind of trend, how do you action that in terms of your own role? To try and how are you measuring the improvements on that?
I think in terms of the public's dealing with particularly their local Gardaí, the local intervention initiative will be a positive step, both for the Gardaí and their local communities, because if under the scheme as anticipated they deal with the small things, well, maybe in time, some of the bigger things they will also properly deal with, which will reduce in complaints coming to us. And it yet has to be seen. It's early stages. It's only just over a year in operation. Also the question, the much bigger question, which is an internal question, is how the Garda service deals with misconduct at every level. And that's something we have no role in. We may recommend somebody should be subject to discipline, but ultimately that's a matter for the Garda Commissioner. And if the system, as Mr. Justice Sharfman said at the end of his dealings with the Disclosures Tribunal, if the system is complicated, lengthy, undermined, then discipline is a problem for the Gardaí and ultimately a problem for the community. We may feed them information under our current remit or even into the future. How they deal with that information in terms of disciplining members will ultimately be for them, and we, like everyone else, will watch that with interest.
Thanks very much.
Thank you very much. Deputy Chambers, Deputy Donegal, please.
Míle mágad agus gur míle mágad Clare as seacht agus tá sean úsáideach agus an stoch an léir agus den réacht in síotá an. Thanks very much. It's been very useful, very insightful in terms of the needs that are there, and I think Deputy Daly has very clearly outlined that a lot of these issues have been seen by GSOC and by others, including this committee, as being requirements that have existed for a long time and unfortunately not acted upon. Just to pick up on, I suppose, one of the previous questions, you said that the feedback you've got is that IOP, or whatever name it ultimately takes, will be up for a start of 2021. Is that to say the organisation up and running? Is that your understanding, and do you think that that's realistic? Do you think that's possible?
We're only going on the implementation body and its proposed deadlines, and it proposes that the terms of the new legislation will be effective from the 1st of the 1st, 21. Now, clearly there'll be transition issues for ourselves and various other agencies, including An Garda Síochána, but it would appear that that is the D-Day, start day for a new organisation as we sit here today.
And do you think that's achievable as far as?
Well, there's no legislation yet, even in draft form, so we don't know what's proposed as a result of Kathleen O'Toole's report. There will then be the process of getting legislation through the Dáil and Shannon. We don't know and have no control over you and your colleagues in that regard. There'll be inevitable unforeseen events that may occur between now and the 1st of the 1st 21, including something like a general election, which could affect all legislative timetables. So there are many issues. We are planning for the 1st of the 1st 21 until we're told otherwise.
Okay. Just, I want to talk to you in relation to protected disclosures. Now, I suppose there's protected disclosures from Gardaí, and there's, but like, I mean, I suppose there was a report there recently, and it outlined that apart from 13 cases which were discontinued, that the other 36 cases which were on the books, that they are still on the books. There hasn't been any case from last year which led to a prosecution or recommendation of disciplinary action. Now, this is the third report of that kind, and the first report, 2014-2016, 9 of the disclosures were undergoing examination or investigation, and 2 were closed. In the 2017 report, of the 31 cases before GSOC, 25 cases were being examined or investigated at the end of 2017, and 6 were closed. In relation to that 6, the Commission considered that further examination was not necessary or reasonably practical. So it seems, if I'm understanding this correctly, that in most years the majority of cases are carried over, and that the remainder have been closed. So am I understanding this right to say that no Garda has faced a sanction from a GSOC investigation following on from a Section 7 or 8 protected disclosure? Is that correct?
That's correct. And you'll recollect when we gave you the business case last year, that one of our main concerns is that we were setting up, for the confidence of the Gardaí, a separate unit within GSOC. We initially started with one investigator, the senior investigating officer. In the course of last year, we finally got our sanction late in 18, and it is only as of last Monday week, that we have finally got our final investigator into the unit. So we have not been able to control the number of people coming to GSOC, and we've only been able to control the number of people working in the last, in effect, 6 to 8 months. Having now got a full complement of people, it is giving us the opportunity to deal with the backlog that has arisen. But when people come to us, we are also telling them that there is a backlog, that we have only recently got a full complement of investigators, and we are saying, if you're unhappy with the fact that this may take some time, you don't have to stay with us, because clearly they do have an option. They are staying with us despite telling them that it is going to take some time. And we know we are trying their patience, and we know there is significant work to be done into the future. But we can't stop people coming to us. I and my colleagues take the protected disclosures at the initial stage, and I pick up the phone and speak to these people. I can't tell them, go away. So we do have a backlog. We hope that the current complement will deal with that backlog. But if you or anyone else is expecting that we're going to clear our books immediately, as we tell the people who come to us, I'm afraid that's just not possible.
I suppose, yes, I understand that, and I wouldn't for a second suggest that people should be turned away, and obviously there is a backlog and that takes time to deal with. But having said that, like not a single case has. Like, I mean, is it the case that, like, I mean, obviously from your point of view, it's simply resource-led, but still in all, like, I mean, I imagine that there must be cases on the books for in excess of 2 years. Is there cases on the books in excess of 4 years?
There was a previous system, the confidential recipient process that was prior to 2014 legislation. And yes, there are the remnants of that still there, yes.
And, like, it hasn't been possible to substantiate, like, I mean, is there, like, I appreciate that there has been a lack of resources, but the fact that apart from the ones which discontinued because it wasn't possible to, I suppose, bear them out or whatever, that there was insufficient evidence, like, I still find it difficult to understand, even with the limited amount of resources, that it hasn't been possible to bring a single one of those cases, assuming that they're not all, I don't know, vexatious or whatever. It hasn't been possible to bring a single one to either a prosecution or a recommendation of disciplinary action. Like, I mean, would you accept that that's, you know, like, that's disappointing to say the least?
It is disappointing, and you'll find no 3 people more disappointed than the commissioners. But can I also remind you and your colleagues, when passing legislation, it made it very clear under the 2014 Act that protected disclosures were permitted in relation to wrongdoings in a workplace. The Act protected these people in terms of their identity. But how then those protected disclosures across the workplace, and I'm not just talking about it in relation to Gardaí, if you go to Transparency Ireland, which deals with a lot of these issues, one of the first practical realities that confronted all workplaces was, how do you investigate an allegation of wrongdoing which requires the protection of the person making the claim of wrongdoing at the same time as you carry out a fair and proportionate investigation? So in 2014, it was heralded, and it was a very important piece of legislation. In the years that followed, GSOC and a lot of other organisations then had to grapple with the practical reality of how do you do the investigation into a protected disclosure. Because of the complexity around the Gardaí, we sought legal advice as to how we actually dealt with these cases. And it has been a step-by-step process to move forward on a complaint, gather information, and at the same time protect the identity of a person. And it hasn't been easy, and that's why, in terms of passing legislation, it's really important to also consider how what legislatively is being proposed is actually going to be carried out. And we're still grappling, and if you go to Transparency Ireland, for instance, and talk to them and their personnel, it's still a challenge for every workplace.
Fair enough. Look, I mean, I suppose I still stand over my view that it's disappointing and I think it's poor, but look, I hope that with the additional resources that perhaps we might see things expedite in that regard. Just a brief question there in relation to last year when you were before the committee, you said about half the cases that we get we can dispose of within the year. This is more generally speaking. Is that still roughly more or less the case?
I think so, yes.
Okay, very well. One of the other issues I wanted to raise with you, and you'll be aware that I put in a Freedom of Information request in relation to a report carried out into the work practices at the Longford GSOC offices related to work practices. And you've refused these requests on the basis that potentially would identify somebody. So I'm going to be careful in my remarks as to not identifying it. But still, it's my view that there's a public interest in the issues that surround us generally. So I will be careful, but I intend to ask these questions all the same. According to the Minister, after PQ I tabled, the there were clearly issues, otherwise the report would not have been commissioned, I would expect. According to a PQ I tabled, the report was drawn up in 2016 under the direction of GSOC's Director of Investigations. It related to a review of workload on hand at the office in Longford. Would you accept, I suppose, first of all, that at that point in time there were issues with the office and that the office was not investigating as effectively as it should be?
You're talking about an office, just so it's clear, where there are a limited number of people working there. And certainly in 2016, there were even less people there. In 2016, GSOC, in its Longford office, its Cork office and its Dublin office, was perhaps at one of the lowest staff numbers, 77 approximately across the organisation. That presented challenges in Cork, which you'd be familiar with, in Longford and in Dublin. I'm not going to comment about an office which in 2016 was limited in terms of the number of people working, because the people involved are identifiable. And unless you're going to say something specific about someone specific who has the right to reply, I'm conscious that we're talking about a limited number of people who were working there in 2016.
My understanding is that the office has, since 2013, had 6 staff, is that correct?
In terms of the Longford office?
Yeah, is that correct?
Yes. Well, in fact, not at all times.
My understanding is that I think if it departed from that, it was only ever very briefly during that period.
I have to go back and go literally through who was working there.
Okay.
And when they were working there, which I'm not anxious to do, even mentally go back through it.
Very well. Are you confident that all files that went through that office were properly investigated and properly managed?
As I say, you're referring to even 6 is a small identifiable number of people. And you want me to say something in a broad sense which could affect people unfairly. If you wish to raise a particular case, you can do that with us directly. And I do remember I wrote to you in, I think it was May of last year, and invited you in so that we could perhaps discuss these things. And I clearly accept you're very busy and haven't had the opportunity to take it up.
I may well do that.
It'd be better dealt with that way.
Yeah, I may well do that, I suppose, in relation to the kind of things that I can't perhaps say on the public record. But, like, I mean, I don't accept that it's not possible for you to say, as head of an organisation, I'm asking you to express confidence that the office was functioning well and that all files that passed through it were properly investigated according to the procedures which you have for your organisation. I don't think that's an unreasonable request.
And I've no reason to say that there was anything that caused me to have any lack of confidence in any of my staff, except insofar that all of my staff at that stage, our staff, were under significant pressures in terms of the resources available to investigate, and clearly that affects anyone's work rate.
Okay. Very well. Thank you for that. I want to also, there is, I suppose one of the reports that have come out in recent years is the report in relation to the death of Shane O'Farrell. I suppose the family were disappointed by it. Are you in a position to discuss reports that have been published?
Yes, and we completed our investigation.
Yeah.
We have sent a file up to the Garda Commissioner recommending certain disciplinary issues that arose as a result of our investigation. As discipline rests with him, I don't know where they stand.
I suppose one of the concerns that the family had in relation to this report is that, like, statements, like, I mean, GSOC is responsible for, I suppose, holding the Gardaí to account and investigating complaints made against Gardaí. One of the concerns that the family had in relation to the report is that the assertions of Gardaí were accepted rather than tested or probed. I suppose one example in relation to that is that the Gardaí asserted to GSOC that issues that happened outside the jurisdiction, that the Gardaí were unaware of it. Now, the family has documentary evidence that the PSNI had in fact informed Garda Síochána of these events. Like, I suppose the report took 6 years. Obviously, there was a lot of time went into it, but I suppose, is it beyond, or was it beyond the scope of GSOC with the resources that existed at the time to, I suppose, to go back to the Gardaí and say, well, are you certain of this, and to seek further documentary evidence and so on, and perhaps to contact the PSNI? Like, I mean, is that something that just wasn't possible with the resources that existed at the time, or why did that not happen?
Well, those were the years, as I've already said, about resources. Insofar as communicating with the PSNI, you may be aware that the Minister for Justice is to, if he hasn't already put before the Dáil a bill called the Criminal Justice International Cooperation Bill, I think its full title is, and the express purpose is to allow for international cooperation. At the moment, we have no right to seek any information from the PSNI, no more than a member of the community has. So we can contact the PSNI looking for information. They can decide to give it or not, as the case may be. We have no protocols with them. We have no operating procedures. We have no formal arrangements. It is anticipated that perhaps under new legislation, both in terms of a new policing act in this jurisdiction, but also the international cooperation provisions, that there may be better communication. So if we ask the PSNI, no more than if you ask the PSNI for information, they may give it to us, but they're not obliged to give it to us. And it is a difficult
PSNI
area.
weren't contacted, were they?
Sorry?
Were the PSNI contacted?
Off the top of my head, I can't answer that question. At this remove, I cannot answer that question. I know we've had contact with the PSNI in relation to other investigations, but I'm not going to say whether that formally happened in the O'Farrell matter, because I do not know. These are matters I know the family, we've met with the family on occasions, are unhappy about. And indeed, there is a further aspect being dealt with by a retired judge at the moment. So some of those matters may be addressed in that process.
Well, I suppose, look, I mean, I leave that apart as it is, but, like, I mean, I do think it's, like, for 6 years, like, GSOC had this report, or this case for 6 years, did not find out this piece of information. The family, without any training or legal background or anything like that, were able to find this out. And, like, I mean, it seems to me it was obviously relevant to the document. The Gardaí made an assertion, it was accepted by GSOC. The family were able to demonstrate that that wasn't the case, and I think that's disappointing. There was, on a separate issue, there was a disturbing report in the Times last July where a member of GSOC was under investigation for allegedly coaching the solicitor of a Garda who was due to be interviewed as part of an inquiry. It was in the Irish Times. You brought in an external investigator to carry out the inquiry. I suppose just in relation to that, like, I mean, the allegations as reported in the newspapers are very, very serious. Obviously that, but also there's an allegation that there was a failure to properly supervise an investigation into the alleged Garda mishandling of a complaint of sexual assault made by a woman. So very, very serious stuff. I want to ask, has this malpractice investigation been completed, and if not, when it will be?
GSOC employees are civil servants in the ordinary way, and they're covered by many of the civil service rules and practices. So when a complaint is made to GSOC about any member, and we get complaints about members, they're referred to our Human Resources HR department, who follow the civil service discipline procedures. And so those matters are dealt with in the way any civil servant would be dealt with when a complaint is made about his or her work. And so those are the procedures that are applied across the board. In relation to the matter that was in the Times, while not surprisingly everything that's reported in the papers we do not accept, insofar as there was an investigation carried out that's completed and no misconduct was found in the terms of what was reported in the Irish Times, or was it the Irish Times or the...
I could check. I thought it was the Irish Times now.
Yeah.
So that's been completed and the matter is settled.
Yeah.
Okay, thank you very much for that. Just in relation to this flow chart here,
Yeah.
the if I'm understanding it right, am I right in saying that if under section 93 is the section for discontinuing of the case, but only if that's done so by that's if an investigator has the file under section 98, they send it to section 93, or they discontinue it under section 93. That's correct, is it?
No, all investigations can be discontinued, whether they're disciplinary or criminal.
Okay.
Can be discontinued where an investigator is satisfied that further investigation is either not necessary or reasonably practicable. I think it's the phrase.
Okay, but if a case goes from section 98 and is escalated to through the director to the commission, that becomes a section 101. Am I right in saying that that can't be discontinued under section 93? That would have to either be referred to the DPP or I'm not sure what else.
Section 1017, since we're getting technical, allows, perhaps for non-techies, if a criminal investigation is completed, the matter comes to the Commission in the form of a report under Section 101. Having considered the report, the Commission can do one of three things. One, can decide the matter should go to the DPP for her consideration as to whether any criminal charges should be preferred. It can decide that there is no criminality revealed but possible disciplinary misconduct and move it in to a discipline investigation. Or under 1017, it can decide, having read the report, that no misconduct is evident and just finish the case.
Okay.
So there are three options: DPP, discipline, or under 1017, finding no misconduct and close the case.
Okay, so once it's been referred through the section 101, it can't be discontinued under section 93.
It
Because
comes
we'll
to
go
us
101,
and we have to make a decision in accordance with what the Act says. It can be discontinued in advance of the 101 report. And for instance, it may be that at a late stage a complainant decides not to proceed. It may be that the person against whom the complaint is made, for instance, is ill or dies, or something happens to cause a decision to be made to not proceed with the matter. But once the report is prepared, it comes to the Commission, and the Commission has the 3 options under the legislation.
Okay. And so far as you're aware, like, there's never been a case that a report has been referred to a Section 101 and then discontinued under Section 93. That's never happened.
I've only been there since 2015.
Well,
Unaware of it, Deputy,
Yeah.
but
Okay.
it's certainly under the legislation that would not be the proper path.
okay, very well. Thank you very much. Sorry, no. I think that's most of my questions now. I might just ask in relation to, am I right in, like, I mean, I suppose I raised an issue last year in relation to discharge of firearms, and the approach there that exists is that there is I think, a strategic information request, I think, is it?
Decision?
Strategic information decision sought from the Gardaí.
I'm sorry.
I may not have the language quite right,
Yeah.
but that the GSOC asked the Gardaí for a bit of information on this strategic information decision or whatever it is, and then GSOC decides whether to take a public interest investigation. I suppose one of the issues, I raised the particular incidents, but I suppose I was a bit concerned that that wasn't related to a public interest investigation. Would you not agree that, like, I mean, where this related to a discharge of a firearm within a dwelling during the course of a raid in Cabra in Dublin, and there was video footage of some of the newspaper websites. Like, would you not agree that an incident like that would be appropriate for a public interest investigation, and should not all discharges of firearms within dwellings be referred to? Should that not require a public interest investigation?
Actually, just any use of force which involves firearms, taser and OC spray as a result of a Garda Directive 10 of 10 and then further directives in 2012 are notified to GSOC, and they should be notified within 48 hours of either the discharge of the firearm, the taser or the OC spray. So we get on a regular basis notifications, albeit not always within the required time frame. We look at all firearms discharge very seriously. We also look at taser discharge very seriously, and look at the circumstances giving rise and consider whether a public interest investigation is warranted. Sometimes we open them, sometimes we don't. There is no threshold as to where we should or we shouldn't. So, for instance, we opened a public interest investigation where a discharge of a firearm occurred at Shannon Airport, where a plane had been landed and detained, and a firearm was discharged accidentally into the tarmac, fortunately causing no damage to property or person. But because of the proximity to the airplanes and also the public place of an airport, we thought in that instance it was important. So we do look at each one, and we could, and maybe now with greater resources, we're in a position to perhaps say we should open one in every instance, but we look at them on a case by case, and we have had to do that in many cases just due to the resources we've had available.
Okay, so, like, I mean, you would have a preference for it, but there's no standard policy as things stand?
No, and I would prefer we did look at all firearms discharges because of the nature of the use of firearms generally.
Okay. I suppose just a final question, I think. I suppose obviously with a lack of resources and so on, and I suppose it's been difficult and it's been slow to investigate every complaint. Has there ever been an incident where GSOC, following some investigation, would have intended to proceed to a conviction or to charge somebody, or to seek a conviction, I should say, but that the statute of limitations of the Petty Sessions Act meant that wasn't possible.
Well, we have under legislation 18 months where there are summary matters only concerned. An indictable matter, it doesn't matter. So insofar as the 18 months is concerned, that's longer than normal, and we recognise that. We also recognise that the 18 months runs from the date of the alleged offence, and if somebody comes to us straight away, then we have 18 months. If somebody doesn't come to us until 6 months, we only have 12 months, and if they come 12 months later. So a lot will depend on when we get the complaint in the first instance. It is our practice to keep a very close eye on the statute, but it's not always possible at the outset of an investigation to know that what we're investigating is only a summary matter. So we may not realise until we've gathered evidence that in fact the seriousness that was given to the complaint at the outset, the evidence relates to a more minor matter. And so we're always conscious of the time frame. And can I say that we've ever come outside the time frame? I can't again say that off the top of my head. It is possible, but it may be due to the fact that I know we have had people who've come to us late and no investigation could have come within the time frame. I know recently the DPP has directed, because it was towards the end, and the DPP immediately considered and directed a prosecution because we were both conscious that time was against us. So we are conscious of the time frame.
Okay, but I suppose you can't confirm or otherwise whether time that 18 months has ever run out and closed the door on a prosecution, or either of your colleagues.
I suppose at the risk of repeating the point the judge just made, very often we're investigating what an allegation makes a very serious offence. Through the process of evidence gathering and processing the various evidential strands, the investigation might conclude that the very serious allegation with which we started isn't actually tenable, but that a much more minor one might be. That would emerge late enough in the investigation. And in that context, certainly, you would come across potential offences that would be by now statute barred, but which weren't apparent to you at the beginning of the investigation. So that would occur.
Okay, thank you very much. Look, I'll just finish with I suppose, look, like I recognise the importance of your job, and I suppose Garda Ombudsman is something that we called for long before it existed. We've seen the value of it in the North, and I hope that the Commission on the Future of Policing recommendations will strengthen your work, and I hope that additional resources will strengthen your work. But I suppose not every element of, from what I can see, is necessarily satisfactory at this point in time. So the work is very important, and I hope that you can continue to do better, and that resources will assist you in doing so.
And I renew my invitation that I gave you last May of certainly come in, and any of your colleagues are free to come in and actually see the work we're doing and talk to us.
Thank you.
Thank you, Deputy O'Leary, and thank you, Judge Ring. I just have a couple of points myself. In a number of responses to members, Judge Ring, you stated that you now have a full complement of investigators. Do I take it from that the 21 outstanding appointments, therefore, are not in the investigator role?
No.
The 21 of 42, are they support roles? Can you like to elaborate? Does that have a deleterious impact, not having them in place at this point in time? What is the net effect?
Well, in every organisation, you have your frontline personnel, so to speak, and you have your support complement, and each is as important as the other. when we made our business case, we were conscious of the need not to end up with too many people who were doing particular work and not having enough support staff within the organisation, or administrative staff. You increase personnel, for instance, that puts strain on your HR department. So you have to have regard to increases in staff and the effect it has on your organisational structure. The other element was we were working within a financial framework, and so we had to have regard to how many persons we could get within that framework. If we had had an unlimited framework, we would have certainly looked perhaps for more investigators and for more support staff. But we were conscious of the financial realities, and taking those realities, we then constructed a case that fit within the financial but also met our needs. But would we like more? Yes, thank you.
Well, I think that came across in your opening statement, and I'd like to support that. As Chair of the Justice Committee, you've made it very clear that one of the real concerns for GSOC is the issue of matching a new remit with resources, and that's going forward. And the in excess of 500 cases gone back to the Gardaí for investigation in 2018. If they're to come under GSOC's direct attention once again, well, there will have to be a significant increase in resources in order to cope. It's very, very clear, and I think you would have the support of this committee in its entirety in reflecting on that, and it's something that we most definitely will do. In relation to some of our own recent reports in relation to community policing and rural crime, you've highlighted in your opening statement the fact that, Gardaí are being diverted from their usual policing duties in order to address the whole plethora of these GSOC investigations, and I use that language quite pointedly. So we're losing their time, their trained expertise in terms of frontline duties, which is what they should be about. It's 15 months since you were here with us last. In that period, I'm still here in the chair, and I deal with all the correspondence along with the clerk on a week-by-week basis. And I'm just going to share with you in a very honest and frank way what I've noted with some disappointment, but all that you've shared with us today, underscores or explains some of this. There has been an increased frequency of expression of loss of confidence. It's happening with a greater frequency. We get a lot of correspondence that isn't and doesn't come under our remit, but people write to us in any event. It's the Justice Committee. I'll vent off and I'll share my experience with them. And I'm sharing with you that there is a lack of confidence factor that is not what we want to see, not what you want to see. And, everyone in political life has a responsibility to help ensure that that doesn't get rooted in any particular way. But, in your own referencing to the emergence of IOPO, am I describing it clear enough? But you make the point, that a resulting erosion in public trust in a new body will set in at an early stage. I have it to say, and with some significant disappointment, it's not will set in at an early stage. It will be carried forward is in fact what will happen if people don't hear what you're saying and what we're reflecting on. And that would be of significant concern to me, that the new body would in fact be starting off not just to prove itself, but carrying a significant carry forward in public lack of confidence. So, you know, Clare had made reference to damage, and my own little note at the time was that the damage has been done to GSOC currently in terms of public confidence by virtue of the fact that the resourcing isn't all it should be. Just in relation to a couple of matters, you made reference to you can't tell them to go away, but I'm familiar myself with a case where, and I suppose I don't know if it's standard procedure, but with the submission of a case to you, correspondence issuing indicated that GSOC will make an arrangement to meet with, interview, explore with the complainant the details provided in writing initially. And then sometime later, a letter issues saying we've decided that, and still no engagement at all with the complainant. How regular would that be? Because I know in the specific instance that I'm familiar with, I mean, it has had a very damaging impact, very respectable, considered people who wouldn't have willy-nilly made a complaint to GSOC. It had substance, it had basis of concern, yet they were never afforded the opportunity that the correspondence from GSOC indicated would be theirs, and that is to be met, to have their case heard, to answer questions, to elaborate, to do what they would have expected and what we all would expect would have been their opportunity. It never happened. They then got correspondence to say the matter is discontinued and no explanation. I have copies of those correspondence, and I wonder, I don't know what you can say to me, but I mean, if it is unusual, and I don't know, or is it something that is frequent, that people don't get their day in court, so to speak, but it's not quite, of course. But, you know, that is a hugely important thing. At least people will have been afforded the chance to expand on the information they've provided. Can you say anything to me on that?
I can say I'd be alarmed to hear that, to be honest. Insofar as we deal with perhaps 2,000 complaints a year,
Yeah.
I can't say I know what you're talking about in terms of the individual case, and it wouldn't be appropriate anyways, but I certainly will speak to you when we're finished about that case. I would be very surprised to hear that someone wasn't given an opportunity to be heard.
Yeah.
And there are procedures. An investigation by its very nature should involve, in particular, somebody who's making a complaint, because we can't know what to investigate unless we get the full complaint. And then the ability to hear, as they're entitled to be heard, the guard or guardee who's been alleged to have done something wrong is also something that's important. And it shouldn't be until those aspects of a complaint are dealt with that a decision is made about the future of the case. So in that sense, I would be very alarmed.
I will speak to you about that, and I'll ensure that you have sight of the correspondence I'm referencing. The last thing I want to, and again, as can be the case, I mean, obviously the case I've just referenced there, a decision, so-called, has issued. A case that has been referred to GSOC of the relatively recent past, and obviously, therefore, I'm somewhat restricted in terms of how I can reference it. But I endeavoured to raise the matter on the floor of the Dáil, to ask a question on behalf of my community in relation to a significant Garda deployment that did have a consequence for a resident in the broader community, an adverse consequence. I don't know the person concerned. I've never met them. I know nothing of the nature of the exercise, but we're talking about a significant number of heavily armed and black-clad members of An Garda Síochána. And all I was seeking to do, because the local media had asked questions of the Garda press office, and instantly very, very short and inaccurate response came, but that the matter is now referred to GSOC. We will be offering no further explanation or shedding any further light on it. Well, you know, living in any community today, and international news and everything else besides influencing people's thought processes, you know, every imaginable possible explanation for this has had a currency. And I really feel that that's not appropriate. People from within the community that the person came from are immediately suspect, labelled, associated with you know, very, very serious matters, of which they perhaps, I'm hoping I'm right in saying this, have no association with whatsoever. So I wonder, you know, first of all, I'm a little fearful because the Minister held to it, oh, the matter is referred to GSOC, we can offer no further illumination. So I suppose maybe the first part of my question would be, would you be concerned that GSOC maybe in some way, by referral of certain matters, is being used as a means of holding back critical information? I mean, we don't, as a public, and I'm speaking as a public, and as their elected voice, I have a role and responsibility to try and elucidate, you know, what is actually happening here. This has not happened in my memory, living in the community all the many decades that I have chalked up at this point in time. This was so unusual. Yet nobody will offer any explanation whatsoever. The GSOC referral is the reason why, according to the Garda Press Office, according to the Minister on the floor of the Dáil, and that causes me concern. So that was the first part of it. Would you have any concern in relation to GSOC being employed or used, misused in such a situation? And would GSOC's address of this particular matter, would it take on board the wider consideration of what's reasonable? People, communities appreciate transparency. They appreciate to have some sense of what this is about. And there is a negative downside that can arise from the holding back of all information. Others from the community that the person came from have come to me in fear because they've known, and every suggestion has been put as to what their wider interests might be, not only domestically but more especially internationally, globally. And nothing could be further from the truth, they say. I don't know. I'm not an investigator. I'm not a member of An Garda Síochána. I am only, on behalf of my community, trying to establish, you know, is this something that's to become a feature of life going forward? How do people address it? Why would the Garda Síochána be so tight-lipped in relation to the matter? I leave it at that, Judge Ring. I'm obviously compromised in terms of how I can refer to it. I hope that I've been careful enough, and I understand that you too, in fact even more so perhaps, will be very careful in replying to me. But I would appreciate some sense of my first question, would you have concerns? The second question, would you look at the wider aspect of being what is appropriate in deploying 20 or more heavily armed people, and what would give rise to such an action? For me, it would be that there was a concern that they might be met by similar weight of force, and nothing could be further from the truth. I leave it at that. Judge Ring, please.
I obviously can't say what's in the mind of anyone who refers a matter to us, except that hopefully they're following their obligations and doing nothing more than that. It's clear from what I've said, and our experience is that not everything gets referred to us. So there's clearly a differentiation as to what comes to us or doesn't come to us. And it would be our hope that everything comes to us as a matter of course, and then we wouldn't have to think into the minds of the referring parties. It has happened that we have got a referral, which is closely followed by a press inquiry, and that's a fact, which raises questions, obviously, for us, as how quickly the press have discovered a matter has come to us, and why is that convenient to the time it's come to us. But what's in the mind of the people that send it to us, I'm afraid I can't speculate. But yes, there are matters that come to us with great speed, followed by even greater speed of queries from the media. We've spoken about our remit, and we've set out in our workflow diagram the restrictions we have. The main restriction, which we've already said we would like to see dealt with under new legislation, is Citizen A complains about Garda B or Garda B, C and D, and that's all we can investigate. We could, in some instances, go beyond that into a public interest investigation, but again, we are looking at individuals. We have no role in operational matters, so we can't tell the guards how to do their job. We can only look at the outcome of their job and whether it displays misconduct, criminal or disciplinary. But again, we're back under our current legislation at looking at the actions of A or B or C. And if A or B or C are acting in accordance with directions, for instance, then that's not misconduct. If it's an operational reason they're in a given place, that's not misconduct. If we can look at an incident from the overview of the individuals involved, that may give us more scope. But we know it is frustrating when people come to us and they complain about an incident, and we have to extract from them or the Gardaí who are the individuals involved. And the individuals may say, we were doing it in accordance with what we were told to do. And all we can say is there was no misconduct. We can't say we thought it was bad judgment. We can't say anything about it operationally. We can make recommendations into the future, but under our current legislation, we have no recommendation powers, and so the Gardaí can ignore our recommendations. So we operate in that maze. It does affect expectations the public have of us, and we must follow the steps. We have said to Justice that we would like a legislative framework which has a complaint, which can be any kind of allegation, which has an investigation that's fair, proportionate, in accordance with the law, and has one of three outcomes. One, the matter goes to the DPP. One, the matter goes to the Garda Commissioner. And one, we find no misconduct by any parties. It's a three-step process, not what you have before you.
The most important word I think that you've shared with us in your reply is proportionate. And I'll take that with me from our exchange today, and I'll thank you for that. So there's nothing further we have to do but to very definitely thank you, Judge Ring, and your colleagues. I have to say, Patrick, you got an easy day today. It isn't always so good. And you're very welcome. Patrick Sullivan and Kieran Fitzgerald, you're both very welcome here as commissioners with GSOC, along with Judge Ring, your chairperson. I want to thank you for your engagement with us, for your opening statement, which has been very helpful. So we are at the end of our business. So at that, the Joint Committee is adjourned for 2 weeks, because next week we're in Select Committee. So the Joint Committee will meet on Wednesday, the 22nd of May at 9 a.m, 2 days before Election Day. It'll be interesting to see how many will turn up. Thank you so much indeed. Thank you.